Hello, hello, hello. This is attorney Mike Gravelin coming to you from Chicago, as usual. Except I'm in my office down on the loop as opposed to my condo. I was down here doing some work, and in between tasks, I ran across this on Judge Marable's courtroom. Oh, oh, it's it's good stuff. It might be too inside baseball. I don't know. I just really like this defense attorney, and it made me laugh. And I thought, why not? Let's do it real quick. All right, let's get this thing started. Hmm. I've got different stuff here. Let's try.
And don't forget to hit like and subscribe, or the dogs get it.
All right. I'm going to call People of the State of Michigan versus Louis Anthony Ford, case number 22T02187FY.
Okay, this one takes a little bit to get going, but stick with it. Paul Scott is the hero, as far as I'm concerned. He is welcome to come on Law Talk with Mike anytime. Paul, well, we can look at a video out of Michigan, so you don't have any issues. I enjoyed his performance today so much.
Count one is intimidating witnesses. Okay, witnesses intimidating, committing a crime, threatening to kill or injure. That's count one. Count two is using a computer to commit a crime.
Thank you, Katie.
For the maximum imprisonment of 10 years or more, but less than 20 years. There's also an habitual offender third offense notice. So let me see. And by the way, they have an alias listed here. Louis Anthony Ford, also known as Ant. A-N-T. Ant. Okay, let me swear you in. Raise your right hand. You solemnly swear or affirm the testimony you're about to give is the truth to the best of your knowledge, understanding, and belief.
Yes, sir.
What is your full legal name?
First of all, he really freaked me out with that. This is going to be before a lot of your times, but when he started testifying, it was not the voice I expected, and he really puts me in mind of Prince, and specifically Prince in Purple Rain.
Louis Anthony Ford.
Can you spell that for my court record?
Louis, Louis, Anthony, Anthony, Ford, Ford.
You know, knee.
Okay. And how old are you?
I'm 26, sir.
Okay. Mr. Scott, is this your client?
It is, Your Honor. Paul Scott on behalf of Mr. Ford. Mr. Ford and I spoke earlier this morning about the 2 felony counts he's facing and the habitual offender third notice that was attached to it by the people. I'm confident he understands these charges, the maximum possible penalties, as well as his constitutional rights. We'd waive formal reading. He's not employed right now. We'd ask the court to appoint counsel on his behalf. I would note, Your Honor, kind of getting ahead of myself here, but he's being held on another pending felony. He tells me on a $10,000 bond. So I don't think he's going anywhere. Just ask you to set a reasonable bond when that time comes. Thank you.
Okay, Mr. Ford.
Yes, sir.
Is it true that your lawyer went over these charges, the penalties, and your rights?
Thank you, MD. Sorry.
Yes, Your Honor.
All I said is Paul Scott is wise beyond his years. He looks so young, but he clearly knows what he's doing. He's a sharp guy, and he's fantastic in this one.
Do you feel you understand the charge, penalties, and rights?
Yes, Your Honor.
Do you want me to go over the charges, penalties, and rights?
No, sir.
Okay. I'm going to find the defendant has knowingly, voluntarily waived the reading of the charges, penalties, and rights. And I'm going to appoint a lawyer to represent you. What was the other, I need somebody to tell me the other case that he's being held on. What the charges?
You wanted me to tell you, Your Honor?
No, I don't want you to tell me.
Look at Paul's face. Paul probably knows, but he doesn't want to volunteer it. He's making the state say it, which is the way to go.
Want either the jail or Katrina can, or you can look it up. Yeah. Somebody. While they're looking that up, let me go ahead and go through the bond, set the date for the probable cause conference. Probable cause conference in this matter will be held August 18, 2022 before Judge Herman. It will be at 11 o'clock in the morning. You understand that, Mr. Ford?
Yes, sir.
Here are your bond conditions. Wait a minute, hang on just a second. He's on probation. Is there a hold, probation hold?
Katrina is walking on sunshine. I haven't heard her be cranky. I think the message got through to her because she's been super cool the last 2 videos I've done. I will say that for her.
That's what you were talking about then, right, Mr. Scott? Was there a probation hold, or you're talking about another charge?
My understanding of my conversation is that he has a pending hold on another felony for $10,000, whether he's on probation and it's the probation hold that he has a bond on, or a separate charge. I will confess not to knowing.
Okay. You can find it? Yeah, please find it. Well, wait a minute. I think I can figure it out. Wait a minute.
It's not a bad idea.
Here's his. What do you need?
Yeah, it's getting old. Yeah, my chat.
All right, so
Knock off the cranky.
I'm going to go ahead and give you your bond conditions. You have to appear anytime. You all right?
Yeah, I'm fine.
All right.
Was that Katrina?
Steps a deuce.
I didn't catch it the first time.
I'll be right back.
2 of them. All right, you've got to personally appear for any examination, arraignment, trial, sentencing, or any time and places directed by the courts. You're represented by an attorney. Any notices to appear will go to the attorney instead of to you. Do you understand?
Yes, Your Honor.
You got to abide by any judgment entered in the case and surrender to serve any sentence imposed. Do you understand?
Yes, sir, Your Honor.
Do not leave Michigan without court permission. Do you understand?
Yes, sir.
Do not commit any crimes while you are released. Do you understand?
Yes, sir.
Notify the court in writing any change of address or telephone number. Do you understand?
Yes, sir.
You would have to report to pretrial services. You understand that?
Yes, sir.
You cannot use any alcohol, marijuana, or illegal controlled substances. Do you understand? You understand that?
Yes, sir.
There would be drug testing for you. You understand?
Judge, it looks like this defendant was arraigned yesterday on that charge. Am I reading that correctly? He was arraigned yesterday by Judge Hammond, maybe?
I didn't go to court yesterday, Your Honor. I'm sorry.
Says Ira. August 6th. How could that be? I didn't see you over the weekend, did I?
Yeah, you saw me on my domestic.
Yeah, okay.
Oh,
Oh, man. Okay, I got it. No firearms or dangerous weapons.
this whole time, Paul is just like, please let this end. Please let this end.
And no ammunition. You understand that?
So,
You would have to have a curfew. I thought I imposed this before, 9 p.m. to 6 a.m. Do you understand that?
yes, sir.
You are not to assault, harass, intimidate, beat, molest, wound, or threaten Destinasia Hoyle. Do you understand that?
Yes, sir.
You're not to have contact or cause a third party to have contact with Destinasia Hoyle.
Yes, sir.
And you certainly cannot go to her house.
Yes, sir.
You're not to use the internet. You understand that?
Yes, sir.
Except as directed by your attorney. You understand that? Okay. Did you want to allocate any further?
I don't. He's being held, so I'd ask for reasonable bond considering that.
Well, I'm going to tell you something. I'm setting this bond to assure his appearance, but more importantly, to assure public safety. You know, this is the type of charge that is one of the most serious kind of charges. It's a serious charge because, I mean, not just because you can go to jail for 15 years on a witness intimidation, or 10 years for the using a computer to commit a crime.
I'm confused, Marilyn.
But it's very serious because if witnesses get intimidated, that breaks down the whole justice system. And that's just not permissible at all.
I just like that rambling from Judge Marable. I happen to agree with him, but he's like, he really, witness intimidation really gets him. Like, yeah, right. It's bad. It's a felony.
I'm going to set a cash or surety bond in this matter of $65,000 cash, no surety. All right, that's the bond. That's it, sir.
So is this a tether bond too, sir?
No.
Okay.
You know what? I'll tell you what.
Sir, why don't you sprint out of the booth here?
I'm
Okay,
gonna,
I'm sorry.
if you should post bond, you're gonna have to be on tether too.
This is why.
I'm sorry.
But I thought he was on tether on the other case.
Yeah, I
I thought he
am.
was on tether already.
Sir, you got to know when to exit the stage.
You know what? I'm changing the bond. That's not even high enough. Make it 165,000.
No, Susan, it's 165.
You sit up here talking about how he's going to run
After he
around, and
talked.
I'm not comfortable.
Sir, I would beg you to leave the booth.
It was GPS.
It's a trend. People of the state of Michigan versus
Okay, that was the good one. This guy comes on, and it's kind of interesting. I guess I'll let it run. Whatever. We're rolling now. But that last performance was so bad that you'll see that it seeps into this one.
Ronald D. Hammaker. Case number 22 T02191FY. This is a charge of bribing, intimidating, interfering in criminal case, punishable by, let me start over. Witnesses, bribing, intimidating, interfering in a criminal case, punishable by more than 10 years. Let me swear you in. Raise your right hand. You solemnly swear or affirm the testimony you're about to give is the truth to the best of your knowledge, understanding, and belief.
I do.
What's your full legal name?
Ronald D. Hammaker.
Okay, so spell your name.
H-A-M-A-C-H-E-R.
Does he have? Here's a case number that I want to look up and see who has that. All right, how old are you, Mr. Hamilton?
75.
Didn't I see you before? Didn't I arraign you before?
I have no idea. I doubt it.
Okay.
You're a hard guy at 75, sitting in on a felony, picking up new charges from jail. I mean, I don't know. I don't know when you turn it around at that point.
Well, is this your client, Mr. Scott?
It is, Your Honor. Paul Scott here on behalf of the defendant. I did speak with Mr. Hammaker earlier this morning about his situation, the charges, the maximum possible penalties, and his constitutional rights. We'd waive any formal reading as I'm confident he understands them. We'd ask the court to enter not guilty plea on the one felony charge he's facing. He's not working. I'd ask the court to appoint counsel. I note at this point, like our previous defendant, he's being held on another charge. I believe he told me with no bond. It's currently in circuit court with Judge Piquel. He did retain counsel on that case. However, as of this moment, he has not retained that counsel on this case. I think it would be prudent, given his incarceration, to appoint counsel for him. And as I advised Mr. Hammaker, certainly if he has means to hire an attorney or decides family wants to hire someone, he can do that. But I think for the first PCC, it would make sense to get counsel on his behalf. Thank you.
Okay.
Did Mr. Scott say which judge that's being heard by with the circuit court case?
He
Yeah,
told
he did. Say it again.
he's before Judge Piquel on a CSC charge.
Are you here to? Is this your? Yeah. Oof.
He's
Been
here
here
to see Judge
a year,
Patel.
nah.
Just a moment, I'll give you the date, Judge.
Okay.
August 15th at 9 o'clock for status conference. That's the next date with Mr. or with Judge
I think that's what y'all think it is, but we can't discuss on YouTube.
Patel.
And there's a no bond. All right.
Oops, I'm sorry, it went back to screen on me.
All right. Mr. Hammaker, do you want me to, your attorney went over the charges, this charge? That's
Me?
true?
I didn't.
Yes, Mr.
I didn't catch.
Hammaker, did your attorney go over the charge, the penalties, and your rights? That's what I want to know.
Yes. Yes.
All right, and you feel you understand this charge, the penalties and the rights?
Yes. I don't
Do you want me
understand
to
how
go
I,
through?
I don't understand how I could have done that. I've been in this jail for 19 and a half months.
Well, it'll become very clear how he did it.
Well, do you want me to go through the charges, penalties, and rights?
He said he understood the charge. He doesn't understand how he got charged with it.
Oh, okay. Here, Mr. Hammaker,
That's Paul Scott going, oh, please, no. No, we're not going through this.
Mr. Hammaker,
Yes.
I want you to be absolutely quiet and do not say a word.
This whole admonition is directly related to the dope that was up just prior to him. He wants to say something to the attorney, but he does not want this guy to incriminate himself. That's not what he's looking for. He's not trying to elicit confessions and stupidity. He just wants to say one thing to the attorney.
You understand?
Yes.
I'm going to speak to Mr. Scott for 1 second, and I don't want you to chime in or say anything, react in any way. You understand that?
Yes.
Looks like, Judge.
What?
This is this afternoon, but it's not what it looks
Oh,
like.
okay.
If you read my note, okay?
All right.
So keep going.
So, Mr. Scott,
Yes, Your Honor.
Mr. Scott, all right. I got a feeling that perhaps some of your clients are unaware that if they make a phone call from the jail, that it is recorded. And in fact, allegedly, the defendant made statements on recorded jail calls to have his son contact family members of the victim to have the victim change her story and offer to provide money to the mother of the victim. You know, so on and so forth. Jail calls are recorded. So, Mr. Scott, you know that jail calls are recorded, right?
I do, Your Honor.
Yeah, there's no doubt. Paul Scott is well aware of this whole situation. He's sending a message to the defendant and anybody else who will listen. Hey, stop doing these things.
All right, so I'm gonna move along here. And do you want me to go over your rights, Mr. Hammaker?
No.
Okay. I want to find a defendant's knowingly and voluntarily waive the reading of the rights, charges, and penalties. This matter will be set for a probable cause conference August 18th at 11 o'clock in the morning before Judge Herman. And I will go ahead and appoint a lawyer to represent you on this charge. Well, what happened when we pulled that case? Oh, that's the 18.
We didn't pull it. It's like the one up at Circuit Court.
Oh, okay, got it.
Tell me in the chat, is that Katrina? Because that woman's really nice. It sounds like her. I think she's had an attitude adjustment, and if she has, kudos to her.
All right. It's a no bond. Okay. Well, if he were to bond out, no alcohol, marijuana, illegal or controlled substances, no firearms, weapons, dangerous weapons, no ammunition, do not assault, harass, intimidate, beat, molest, wound, threaten any witnesses.
I mean, I get it. He's just doing the order, but the dude's incarcerated and he ain't getting out.
In his pending court cases. All right. So anything before I set the bond? I guess it's a no bond in the other one, so I guess it doesn't really matter, does it? What do you want to tell me?
Nothing further, Your Honor.
Cash or surety bond of 165,000. Okay, that's what it is.
Okay.
Step out, Mr. Penmaker.
All right. Thank you.
Well, there you have it. I really just like the first appearance so much, but it was amusing to me that the first appearance was so bad. He had to modify what he was saying in the second. Then once we got there, I thought, all right, we have to go to the end of the appearance so you can see what happens. He sits big bomb. That guy's not going anywhere. He's no a bunch of trouble, and that's that. But I really did enjoy that attorney. I mean, it's worth another look. You got to watch his facial expressions while this is going down. He's just like, oh no, you didn't. No, you didn't. Oh, I don't know. Maybe it was just therapy for me. I don't know. It was too much fun. Oh, let me see here. Thank you, Ann Larson. I appreciate it. And thank you all for coming out. I will see y'all soon.